Everyone, as you know, late yesterday, Judge Barker issued a preliminary injunction against the various provisions of 404, Senate Enroll Act 404, that we had sued, the ACLU of Indiana, had sued on behalf of Planned Parenthood, who was representing itself and its patients. Specifically, the judge has enjoined the provision of the law that would have required or juvenile courts that considered applications by minors to obtain abortions would have had to consider whether best interest existed to notify the parents of the abortion request, even if the juvenile was deemed to be mature enough to decide on whether to have an abortion. The court also enjoined the provision of the law that would have prevented Planned Parenthood from giving advice to its patients concerning the ability to seek abortions outside the state of Indiana under the provision that would have prevented anyone from knowingly or intentionally, aiding or assisting a pregnant minor in learning about options other than what's in Indiana law. And finally, the court enjoined the provisions that would have required Planned Parenthood and its doctors to both verify identification and sign affidavits under a very vague standard that they had received sufficient information that a reasonable person would believe that the people before them were the people who they said they were. These provisions together would have greatly burdened the ability of persons to obtain abortions, particularly the provision concerning the option of requiring parents to find out if a minor was seeking abortion would have deterred young women from seeking abortions in Indiana. So we are very, very pleased that here we are just days before the laws were to go into effect, that they have been enjoined. This is a preliminary injunction, which means it's pending final resolution of the case. At this point, the state does have the option of appealing this decision to the Seventh Circuit or letting the case go through to a final decision after trial or other motions practice. But as of today, the law has been enjoined. So Betty's here to talk about it, and then we'll take your questions.
Hi, good morning. I have to say that this is a pretty fine last hurrah for a woman who's one day away from her last day on this grand 15-year tour of duty with Planned Parenthood of Indiana and Kentucky. I get to take this opportunity to sing the praises of the extraordinary ACL of Indiana mission that's led here in this location, the partnership that we've enjoyed, and just knowing that they're there every day to protect all of our civil rights is a great thing. And I'm really, really going to miss this guy, although I do get to show up as a spectator because there will be other opportunities, I am sure. Of course, we're delighted with this outcome. It's absolutely certain that we're talking about young women here in Indiana who are already dealing with an incredibly difficult situation. And the persons in the State House who think it's okay to put these things into law have no notion of what they're going through. And it lacks intelligence and it lacks compassion, and it's a very great thing that Judge Barker understands that it makes sense for this to be enjoined at this time.
Questions?
Is there a constitutional protection for parental supervision? Or are there two constitutional rights in conflict here, or
the Supreme Court has long recognized a fundamental right that parents have in relationships with their children. But when the Supreme Court decided the case that held that children have an absolute right, young women have an absolute right to obtain an abortion without parental consent, the court found that due to the interest in when you have a young woman who's pregnant, that her rights at that point are stronger than the parental right to block the abortion. And therefore, if the young woman is deemed to be mature, and the vast amount of bypass cases, these are called bypass cases because you're bypassing consent, the bypass cases involve juveniles who the court determines are mature. When you have a mature minor, the Supreme Court said she is to be given the same right as a mature adult to obtain an abortion. In the same way that there's a fundamental interest between husband and wife, between spouses, the Supreme Court has held that a husband cannot block a wife from obtaining abortion. The Supreme Court has held a parent cannot block a child. And what the court recognizes here, as many cases have recognized, is that giving parental notice is in effect giving parents the opportunity to block that abortion. And in fact, we had evidence to demonstrate that is exactly what can happen, in addition to other harm that can befall the young woman. So this is a balancing of rights, but the right to privacy that encompasses the abortion decision that is personal to the young woman is the prevailing right here.
How does that happen? How does notification rise to the level of law?
What the court found and what our evidence demonstrated is that it is not infrequent when a parent finds out that the parent will actively prevent the young woman from obtaining an abortion. We had one example of that here in Indiana. There is also evidence from people around the country of abuse occurring, of young women being tossed from their homes, of all sorts of problems occurring with parents who do not want the abortion to occur. And the Seventh Circuit, which is the appellate circuit over Indiana, recognized years ago that frequently the right to get notice becomes the right to block consent.
Betty, this is fifth or sixth victory in the last 5 or 6 years, but given the rumblings of potential change at the federal level in the U.S. Supreme Court, are you worried that in the next few years victories like this will become less frequent?
Ideally, the need to seek these victories would go away, but we're not so naive as to think that might happen. And of course, what's under consideration in D.C. is always a concern for us, and we will always get out there with the message that ideally everyone would understand that the way you reduce the incidence of abortion and issues like the one we're talking about this morning is through education and access to birth control. And there's a real fear, given what's under consideration in Washington, that could be eroded.
Am I misremembering the text of the statute? I thought that this was a notification after the fact.
No. No, the way the statute is written is that the court is to determine whether it's in the best interest of the child that notice be given prior to the abortion. So the statute sets up this dichotomy of a court finding, yes, you are mature enough to make the abortion decision, therefore your parents do not have the right to consent, but still saying there might be situations where your parents are going to be told, and that's the problem. That's the constitutional difficulty that we pointed out.
One further thing I would observe is that ideally parents are involved in this kind of situation, but we all need to recognize that the world is not always on the ideal side, and that consideration needs to be given, that these young women are in that kind of circumstance.
Although one of the other areas that the injunction was granted concerned the type of identification that Planned Parenthood had its doctors, and an affidavit the doctor has to do in situations where parents do consent. And the evidence is that more than 90% of the time parents do consent, but this statute even erected roadblocks to that.
Judge Barker in a ruling noted that the issue, the part of the state's argument was that this is a pre-enforcement challenge, and they were trying to say that it shouldn't go through because of that. And there is sort of unsettled case law here involving it, including the Seventh Circuit. How confident are you, if this were to appeal to the Seventh Circuit, that it would survive on that question?
I think the lesson the Supreme Court gave us last year in its most recent decision concerning abortion is that you have to balance the evidence on both sides. What is the evidence of harm that a law will cause? What is the evidence that this will in some way benefit some state interest? Our contention was there was no evidence to benefit the state, and we do have actual evidence as to the harm this will cause, so we feel good about our evidence.
What is the scale that we're talking about here? 90% of minors seeking an abortion parents are giving consent. How many cases are we talking about where they have to go through judicial bypass?
I don't know if there is an accurate statewide figure as to how frequently that occurs outside of Planned Parenthood. I don't know if you know.
It's, those records are not centralized, so, but it isn't a high number. It's just an incredibly important number.
And of course, part of the evidence in this case demonstrated that if young women knew that there was even a chance that notice would issue to their parents, they would not even proceed. So we were dealing with a potential number as well. Well, thank you much for coming. Hopefully we won't have to do this again next year at this time, but we'll see.
Yeah,
Well, and
happy,
we'll do it- and
happy
we'll do it without her.
Independence Day. You're gonna do it without me.
There always are.
Let us know if you guys want to interview anyone one-on-one in
I never,
particular. or
ever
if you
turn it on.
I'll watch movies with my wife sometimes, but I never watch